Before we start, let me tell the audience what the facts of the situation are. Our applicant is a software engineer. She works for company A in India, who has developed some software for a US client. US client is company B. Company B wants company A, her employer, to send someone to the US who has worked on the software development to train the employees of company B in the United States on how to use the software. The applicant was chosen because she handled the software development in India. A little visa history. She's been in the U.S. previously on an H-1B visa for 2 years while working with her previous employer. She did not file taxes in the U.S. for her second year. Her tax situation in India is up to date, and she's never been rejected for a visa before. She's asking for a duration of 3 months to come to the United States. So let's get started. First question, where are you currently working?
I'm working for company A, which is as a software engineer.
Okay. And why are you going to the United States?
I think there's some training at a few client sites. Either they will train me on something, or I will be training them on our products.
Okay. What does your company do in India?
My company in India is a software development company. We develop software for clients all over the world.
Okay. When are you going to leave for the United States?
As soon as I get my visa.
Okay. And who is paying for your trip?
I think the company is going to take care of it. I'm yet to receive my air tickets.
Okay. Where will you be staying in the U.S.?
Probably some hotel, or I have a cousin staying in LA, so I may stay with him too.
Okay. For how long are you going to be in the United States?
My company is arranging everything, so I don't really know the duration yet. However, I also have my cousin's marriage coming up in January, and it would be good if you could give me a visa for 6 months.
Okay, I'll see what I can do. All right. Will you get your salary in the United States or in India during your visit?
They'll be paying me some dollars in the US for my food, but my salary will be credited in my Indian account.
All right. Why have you been chosen for this assignment?
Well, our team leader just left the company last week, and I was the best option they could find.
Okay. Have you ever been to the U.S. earlier?
Yes, I've been there once on a B1 visa.
Okay. And what were you doing in the United States?
I was working as a software engineer for some maintenance work.
Okay. Who did you work for?
I was working for company Z.
All right. Do you have family in India?
Yes, I have my parents and my younger brother.
And I'm going to do this one first. Do you have any relatives in the U.S.?
Yes, I have 2 cousins. One is in LA, the other one is in San Francisco. I have my maternal uncle in Vermont, and I also have a couple of friends studying in Austin.
Okay. Are you married?
Not yet. My parents are looking for a guy. He's currently in New Jersey. I think things will get finalized, and I hope I get married next year.
Okay. All right. Everybody follow that? I'm needless to say, I'm going to deny the visa at this time. It's denied without prejudice, meaning she can reapply at a later date. There's nothing fatal about this interview. It's just we need a little different approach to the answers. And let's go through some of the questions and answers and tell you where the problems are. All right. Why are you coming to the United States? I think I'm coming for some training. I may train somebody or they may train me. So the applicant needs to know what the visa is all about. This is where the company needs to brief their employees before they go to the consul. And to be consistent with what's in the letter on a B1 case and what's in the H-1B or the L-1 petition in those cases. Anytime the answers are different from what's in the paperwork, there are discrepancies that raise issues, and you're probably dead in the water at that point. who's paying for the trip? Well, she didn't know. She thought her company was taking care of it. Well, don't say I think this or I think that. Be sure of yourself when you speak up. If you don't know, you don't know. But don't say I think this or I think that. Where will you be staying? Well, that's something pretty basic. The hotel or the cousin in LA? Well, shows me she's uncertain of a lot of things. So how long are you going to stay in the US? Well, she didn't tell me a duration for the business, but she told me she needed 6 months to attend the cousin's marriage. So again, obvious problem there. Now that brings up a subject. I always tell people when I was a litigating attorney, I would always tell our witnesses, listen to the question from the other side very carefully, answer the question, no more, no less. Don't volunteer information. It's good advice in a consular interview. If the consul wants to know more, he or she will ask another question. Don't volunteer information because, as will come up in this case later, an answer may lead to other problems. And maybe if you had answered the question alone and not volunteered the problem information, maybe you would have gotten a visa. In this case, no way she was getting a visa, but it's a thought. Salary was okay. Why have you been chosen for the assignment? The team leader left the company last week. Well, that tells me there wasn't a real in-depth search for a qualified person to come to the United States. So there are issues with that. Do you have relatives in the U.S.? So this one, again, is not responsive to the question. 2 cousins, one in L.A., one in San Francisco. My maternal uncle in Vermont. I've never heard of a maternal uncle being close enough in relationship to help or cause a problem, but okay. And a couple of friends who are studying in Austin. Well, the question was relatives in the U.S., and a couple of friends are not relatives. So non-responsive to the question could lead to other issues. Maybe you should be staying with the friends in Austin and not really working for the, violated my own rule, attending meetings with the other company. But my favorite question is, are you married? Not yet. My parents are talking to a guy who's currently in New Jersey. If things get finalized, I may get married next year. Well, the problem with that is the answer to the question, are you married, is yes or no. It's one or the other, but it's certainly not this answer. But this answer, where she volunteered information, raises a major problem. I may be getting married next year. Well, husbands and wives generally live together when they get married. This August I'll be married for 40 years, and I've lived with my wife every single day for 40 years, so I do know. Same wife, by the way, only one wife. No, she's a wonderful woman, don't get me wrong. But the issue that may come up, and it's not a legal issue, it's just an issue I'll mention. The consuls may think that if she's marrying a guy in the U.S., the guy is probably a U.S. citizen. Maybe not, but probably. And since husbands and wives live together, she's coming to stay permanently in the United States. Now, remember, this is a B1 visa. And remember that concept that we talked about very first thing this morning, intent. Non-immigrant visas like B1s require strictly non-immigrant intent. Any mention of anything that implies that you may stay permanently in the United States, like marriage to someone living in New Jersey, can raise some real issues about your intent. And I could have, although ambiguous, I could have denied the visa for that reason. So now, let's talk about procedures. Remember what I said about being prepared, look the consul straight in the eye and answer the question, no more, no less, don't volunteer information. A lot of things were volunteered here, some of which caused me a real problem with the case. Be aware of what the case is all about, be consistent with what the paperwork says. Have the company brief you before you go to the consul. And just a side note, whatever you are briefed to tell the consul in the interview, don't forget it when you leave the consul with your visa, because the CBP officer at the port of entry, when you land in the U.S., can ask you all the same questions all over again and more if he feels like. Do they, as a practical matter? No. But if they have some reason to, they will and they can. And people have been denied admission to the U.S. even though they're granted a visa. Visa is no guarantee you'll get in. The officer at the airport makes the decision. And I didn't mention secondary inspection yet. If you arrive, get off the plane, go to the first officer, primary inspector at the booth, and he has any doubts or hesitation, he's going to invite you, well, he's going to insist that you follow the line on the floor to the back room called secondary inspection. And you will be sitting there for the next 4 to 6 hours. If you have a connecting flight, you'll miss it. Who knows where your luggage will go. And you'll be answering questions for 4 to 6 hours, and a transcript will be prepared, and you'll be required to sign it, after review, of course. So if there are any doubts, they may start questioning you in a lot more detail. So it's important to have your answers clear, concise, don't volunteer information. My point is, be prepared. Pay attention and just answer the questions. She can try again. Remember, there's an intent issue. Know what the visa is all about, the purpose of the trip, and I don't need to know about the maternal uncle in Vermont or the guy in New Jersey. I don't need to know about all that stuff. So good luck next time. All right. At this time, any questions from the floor on the consular interview? Yes.
Yes, this is related to the same case like David, and we had a young person, a teammate from our organization who was supposed to go to the US. Exactly the same situation like training decline. The case was well documented. The person who was giving the answers, he was denied it on very generic terms, saying either your purpose is not clear or the ties are not strong. So the client was entirely, so they actually gave another letter emphasizing the need, and they, from their lawyer, and it was well drafted that it is, that there is no long term or anything like that, and they are also getting the work back in the US. So we are basically transferring. So all that thing was covered, and this person again went and gave the same. He attended the interview nicely, gave appropriate answers, had a proper documented training program as well, and he has a property which is not the apartment but a land in his name. So all that was there, and then this time, the second time, they gave a reason saying that you do not have enough strong ties. So basically, we interpreted it as like he's unmarried, so that's all about it. I mean, he stays with his parents, so in Indian context, yes, that's a good, strong enough reason to problem not in the US. So, do you have any suggestions or what are your thoughts on such cases?
I have several thoughts, and since it's a B1 case, it's a non-immigrant intent case, it's a 214B case. 214B is a section in the Immigration and Nationality Law that says, as I may have mentioned, there's a presumption raised in the law that when you apply for a non-immigrant visa, you are intending to immigrate permanently to the U.S. In other words, not come back to India. And you have to overcome that presumption with enough evidence of showing permanent ties to India that make it believable you'll come back. You have something to come back to. What do they look for? They look for permanent ties consisting of strong financial, economic ties, an ongoing job, social ties, and family ties. Ownership of property, a long-term job, family, that sort of thing. Now, when you're young and unmarried, just out of school maybe, I don't know, or just recently hired by the company, not a long-term employee, consuls seem to think, I'm convinced they're trained this way, that you're not old enough to establish any permanent ties. You're a free spirit and you're going to go where the action is. So you're going to stay in the United States It's a profile. And it's just a fact of life. At busy consuls, everyone in India is a busy consul. They only have 2 minutes or so to deal with the case. And they glance at the application form. They don't read it. They glance at a few key questions. They walk up to the window and call you, and they've already made up their mind generally. Consuls have told me this, based on profiles, whether they're going to grant the visa or not. One of the profiles I hear all the time: young, single, female, applying for a tourist visa or a B1 visa. Denied, 214B. What's the profile? Young, single, female. Consul is trained to think or conclude or profile that she is coming to the U.S. for one reason alone. Now, anyone want to guess? I'll give you 3 guesses. The first 2 don't count. The profile is she's coming to the U.S. to look for a U.S. citizen husband, preferably with money, get married, and get a green card. Very simple. That's how they're trained to think. And in many cases, in many countries, that's probably true. But what if you're the one exception to the profile? What do? Well, you go in knowing about the profile, and you think of every single thing you could possibly think of to stay away from the subject and emphasize more positive things. That's all you can do. Another profile, more to your purpose, relatively new employment to the Indian company, employee of the Indian company. Now, this one bothers me. I disagree with it. They look at how long you've been with the employer who's sending you to the United States. And lately, and they must have added a chapter in the training book. Lately, I've had a lot of inquiries about, well, I'm a key employee of the company, but the consul denied me because I haven't been with the Indian employer long. I've only been with the Indian employer for 2 or 3 months. Well, the focus is not generally on how long you have been with the Indian employer. It's what your importance to that employer is and why they picked you to come to the United States, okay? Someone has 15 years experience on a particular unique project or knowledge or intellectual property, and they're hired by company X just for that reason, and to send to the United States to meet with the customers or clients, implement software, troubleshoot, whatever. Well, the fact that they've been with the employer in India for only 2 or 3 months shouldn't be where the focus is. It should be why they're a key employee of the company. Why were they hired? Focus on why they were hired. That'll make them a key employee, and it's irrelevant how long they've been with the company. So I see a lot of those lately. Any more? Go ahead. Microphone's coming.
A 10-year experienced person joins a company, and within his 1 month, there is the opportunity for him for a US customer wants him for a year. So, what visa is recommended?
What is the opportunity again?
Yes.
He
is a 10-year experienced professional.
Mm-hmm.
He joins this company. This is a new company for him. He is there for only 1 or 2 months. But there is a need, project that this fellow needs to be in USA for a year. So what is the possibility of visa? He needs to go there for a work. And he has not completed 1 year. So we cannot go for L1 visa, not A or B, because that it will not be eligible. I believe there is a 1 year when he should be with the company.
Okay.
And H1B cap has 1st October. So what that company should do?
Okay. You stated the problem very well. Do you need a job working for my law firm? Because I could use you. You're right on top of the issue. Yeah, H-1B cap is exhausted, hasn't worked long enough for the company to qualify for an L. What do? Well, your only option is a B1 visa. Now, are you going to get a B1, are you going to get a B1 admission for a year? Probably not. I explained that earlier today. So what I would do is I would be a little bit more reasonable in terms of the time needed to come to the U.S. I would reduce it from a year significantly, make it a little more reasonable and marketable to the consul. Remember, you have to tell the truth, but depending on what your needs are, you may be flexible. So, but The only one is a B1 now. The analysis is, what are you going to be doing for that year or 6 months or 4 months, whatever it is. If it walks and talks like employment and smells like employment, the consul's going to say you're coming to work and you need a working visa. So you're going to need an H or an L or whatever, and they'll tell you, go get an H or an L or an appropriate working visa, and you won't get the B1. So use the key buzzwords, meetings, technology transfer, training, but be a little more reasonable in the time requested, okay? What you ask for must be consistent with the factual situation, okay? Other questions? Right here.
We apply for business visa. The person has to travel to US for software installation.
For what, sorry?
For software installation.
I don't know that I would phrase it that way. Can we phrase it a little more broadly, like a meeting with the clients about software installation and maybe he's not doing the installation himself? As long as it's true. Okay? In back.
One of our seniors, almost 7 years with us, and recently applied for B1 and got the selection. The reason was that during the interview, a lot of questions were there about his earlier travel to Middle East. It was not with us, and then he was with some other employer. So how do we deal with such cases?
He was questioned about his previous travels to the Middle East.
Yeah.
It's not uncommon. Since the 9/11 terrorist attacks in the year 2001, the U.S. immigration world turned upside down on that day. Virtually everybody coming to the U.S. is considered to be a disguised terrorist, even your grandmother, okay? So that's how they think, unfortunately. That's how they think. And you just have to deal with it. It's a fact. He traveled to a part of the world where there's a lot of trouble, and they want to be sure he's not a terrorist. So maybe a way to prevent that is be prepared to document the business-related or family-related reasons why he went to the Middle East, in case it comes up. Okay? One more, and then we can talk in the Q&A session. Right here in the middle row here.
You just mentioned that the council may have already made a decision on their case before even you reach the window. Does that happen even for other cases like for L1A or L1B? And if that is happening on what basis is that decision made by the council before you reach that window?
Okay. No, I mentioned that in the context of visas that require strict non-immigrant temporary intent, like a B1 business visitor, a B2 tourist, and the other typical one is an F1 student visa, okay? For an L1 or an H1B, generally it's not an issue. Generally, until fairly recently, consuls will defer to the already approved petition approved by USCIS in the United States for an H, for an L. They generally won't question an H or an L, go behind the approval, unless they have some independent basis. Now, what's an independent basis? Well, on the H-1Bs, who's the employer? The client or the software consulting company? There's a whole lot of that going on, okay? L1B, specialized knowledge working offsite at a client site, same concept. Those cases are getting referred back to the service center that approved them for study, for revocation, based on questions from the consul about further details that the service center didn't have. I saw a rejection or a request for additional evidence come out of Mumbai recently for a software consulting company that had at least 25 requests for evidence on it, and they just checked the boxes they wanted answered. Well, this particular case, they checked all 25 boxes. So they will at least look at the answers to those additional questions before they send it back for revocation, okay? So just be aware of that.